Hey, everybody. I'm told that it's starting by our office manager. Um, so I'm just going to kind of go slowly here while people matriculate in. Today, we're going to be talking about tendering claims to insurance carriers. My name is Chris Matheson. We use the word tender. It's sort of an old time expression. It is make sure I'm not muted. It basically means to offer or for consideration to the insurance carrier. It is a term of art, and so sometimes people are confused by that. But trying to use the correct terminology for what we're doing, which is providing notice to the insurance carrier of claims. So that's why we have the funny terminology. As I said, my name is Chris Matheson. I am been an attorney for over 20 years. I've been here at MEEB for several years. I look different than in my bio pic. Let me see. Let's see if we've got people in here. So for just as a background, so you understand where I'm coming from, I did for about 10 years. I was in Boston doing a wide variety, usually construction-related litigation. And then for over 10 years, I was in Seattle, Washington, where I was worked at a firm where I was a partner at a firm where or I represented a lot of developers, and then developers of condominiums, so it's kind of the bad guys. And then later on, represented the homeowner associations themselves, which are usually called HOAs out on the West Coast. I handled a wide variety of litigation for homeowner associations, all the way from just the usual construction defect claims, dog bite cases, personal injuries, all the way up to wrongful death cases. And then during the pandemic, came back here, and I've been working for MEEB and loving it for a couple of years now. I am in the litigation department, and the litigation department is here at MEEB, and that's the department that you generally don't want to see and you don't want to talk to, because if you talk to us, it means that you've been sued, or at least you've had a lawsuit threatened. And that first idea is kind of important. It's not just the receiving the notice of a lawsuit, but it's the original threat. And for tendering claims, we really want to talk about when is one of these claims being alleged, when are they being threatened, when is there a actual demand letter that you receive, and ultimately when do you receive the lawsuit? Because all those are important, and the insurance carriers are going to be looking at that. So we're talking about tendering to our insurance carriers for the association. And the association, because I'm in litigation, I don't help out with procuring insurance, but I do a lot of work with tendering to insurance. And so there's usually two insurance carriers that we're talking about here. We're talking about the master policy, and we are talking about the D&O coverage, or the directors and officers coverage. And so we want to talk a little bit about what those two policies do and what's the differences in terms of the claims. But what we don't really get into are the HO6 policies. Those are the policies, as you know, that the individual unit owners have. We wouldn't tender to those because those aren't the association or the board's policies. Those are the policies of the individual unit owner. I have a question here of who files the claim. That's sort of an academic thing. You probably have someone in-house who, or not in-house, but an insurance broker or the property manager, property management company that coordinates that and helps with that. So we would expect them to tender to the claim, but whoever is your normal person that is going to do that, I would rely on them to tender to what is usually either the master policy or the directors and officers coverage. Master policy, we know that's usually a general liability policy somewhere as part of that master policy, covering a wide variety of perils, or perils being the term of art that insurance carriers like to discuss regarding damage to the property, which is where most of the claims are going to originate. Most, but not all. And for other claims, we've got the D&O coverage. Now, the master policy covers sort of the association itself. The D&O, directors and officers, is insurance that's specifically designed to cover the directors and officers of the association. That is the trustees for the association. If you are, like I say here, if you're volunteering for a board, you really want to look into and make sure that you've got D&O coverage covering you. It's very, very useful. Now, we do see it a lot of times. I get frustrated because D&O carriers very frequently deny coverage. But we can get into that in a little bit. It is something that you want for the if you're volunteering for a board, and it's important. It covers things like breach of fiduciary duty, discrimination, and disregarding governing documents of the condominium. So what we frequently see is you get the lawsuit in or the demand letter, and it's alleging, let's say it's a garden variety water intrusion claim by a unit owner. What you're going to get is you're going to get some sort of negligent maintenance claim for failing to maintain the common areas and allowing this water intrusion to happen into the unit. But you're also going to get a claim like a breach of fiduciary duty, which is saying that you, the individual trustees of the condominium, breached their fiduciary duty to the unit owner when they failed to properly maintain the common areas that allowed the water intrusion, or they failed to make repairs in a timely fashion after that water intrusion was, after they were put on notice of the water intrusion. So you get these two sets of claims. If when you think about it, one is, hey, I was damaged because of water intrusion, my unit was damaged. And then the other one is this more esoteric, you guys, the trust, didn't do your job properly when you allowed this water intrusion to happen. So in those cases, you really want to, I recommend, put the carriers for both policies on notice. It doesn't just affect water intrusion cases. If you've got, recently we had one where the unit owner recently purchased the unit and claims that certain parties promised him not only the 2 parking spaces. Everyone gets 1 parking space, but in his case, he claims to have been promised 2 parking spaces, and says that the property manager, trust, everyone should give him the 2nd parking space. That's, to me, when it's directed towards the trust and the trustees, that's more of a D&O claim than a master policy claim. And in those cases, I believe in that case, we had the D&O coverage in place, so that was great. Another thing that this can come in handy for is if you receive claims brought to the Massachusetts Commission Against Discrimination, MCAD. In those cases, you can tender those claims for defense and indemnity. And in that case, I think the D&O coverage should be the one that steps up, since, as you see right on the slide, it says the word discrimination. That's what it should cover. But in fact, what we find, I was talking with someone recently here that said that they found coverage under the master policy. So great. All right. We'll take coverage wherever we can find it. So the next question is, when should tender be? I'm going to take a water break here because I'm struggling from a cold that I've had for quite a while. But when should tender be made? Well, as a general rule, I would just say as soon as practical. You should tender the claim. Put the insurance carrier on notice, either through your insurance broker or through your property manager. I just want to talk briefly about the differences between claims made and occurrence policies. And then we'll talk just a little bit about late tender, which is a very frustrating defense that insurance carriers use to deny claims. So there's two basic kinds of policies that talks about when claims need to be made. There's claims made and there's occurrence-based. Claims made, the policy will cover a claim that's made and reported during the policy period. So that 1 year period, you need to have that claim made and reported to the insurance carrier during that 1 year period. After that period ends, even if the claim originated during the policy period, the insurance carrier will deny the claim because it was not notified of the claim during the policy period. The other kind is occurrence-based, which covers all claims that occurred during the policy period, during that 1 year period. So if you have a if you have a claim that is made outside the policy period, but originated during the policy period, you tender to that insurance carrier and they have to cover it. This is for high stakes litigation when you're dealing with maybe different policy, different carriers over a long period of time, and you need maximized insurance coverage. These become very important questions. For smaller or mid-sized cases that happen on one date, and we're just worried about which policy to tender to. These questions are a little bit easier, but this is something that can get your claim or your tender denied. The problem now with late tender is it's a very common reason that insurance carriers deny tender. And so this is sort of how it works. The carrier isn't looking at the date that you provide them notice. They're looking for the date that you were provided notice originally. And so you can get a demand letter, try to work something out. A month later, it all falls apart and they file a lawsuit. And then you take the lawsuit and you tender it to the insurance carrier. All right, that's not a big problem. It's 1 month. You're not going to get it late. You're not going to get an insurance carrier who's going to claim late tender in that case. But here's a situation that I see more frequently. Someone is complaining about some water intrusion in their unit. The property manager goes in there. They think they identify the issue. And for the most part, they have identified the issue. Maybe some sweating coming off of pipes because of humidity. All right, we have to set up some protections to collect that water. The issue seems to be resolved. 9 months goes by, and there's an issue with the unit. And so the trust and the property manager go in and they say, all right, well, you're using this unit improperly. Maybe you're running a business out of it. You have to stop with that. In that case, what happens is what we see, and it happened recently, the unit owner then turns around and says, hey, they retaliate by saying, oh, you never fixed that original problem 9 months ago. And now I want that fixed. And they gin up some reason. And now what you find yourself is they send a demand letter and a lawsuit. You send that off to the insurance carrier. And the insurance carrier looks at it and says, hey, this water intrusion claim, what's up with that? You had notice of this 9 months ago. Well, why didn't you notify us then? And our response is, well, we tried to fix it. Like we were operating in good faith to try to fix this. We didn't think it was necessary to tender. And the insurance carrier will or may try in that sense or in that case, to try to say, you know what, it's late tender. You've prejudiced our ability to defend your claim by not informing us of the claim in a timely fashion. And they do that. And then you've got to fight back on that, which is and in those cases, I would say contact, if you haven't brought us in or you haven't brought an attorney in by then, it's a good idea to bring in the attorney. We do have a question. First, I want to say hi to Leah. She sent a message about she had worked out in Seattle too. So that's interesting. But I do have a question from Joshua, who is asking about notifying an insurance agent. Does that count as a tender for timing purposes? And as opposed to, so in this case, the association notifies the insurance agent, doesn't notify, and we don't know exactly what's going on with the carrier, but does that count as tender for the timing purposes? No, it doesn't. The insurance agent, if it's an agent for the association, it hasn't been tendered yet to the insurance carrier. You got to tender it to the insurance carrier. And so that's the operative date. If the insurance agent for some reason, sits on it, something happens on that end. If anybody sits on it, that is essentially an extension of the association. So and you're going to be, the insurance is going to hold you accountable for the actions of the agent. So if the agent doesn't tender in a timely fashion, you essentially have not. That is a good point. I appreciate the question, and I would say that would add that to my slide. You should follow up with whoever you have tasked with the job of tendering, be that a property manager, insurance broker, attorney, anyone. Make sure that got tendered, so that way you have some assurances on that end. I'm just going to say this. One of the reasons why late tender is so frustrating is because in our scenario that we have where there's some sweating from pipes and there's some water coming down on the floor and it's doing some damage, you think you fixed it, you don't tender it, and it comes back and bites you. Well, interestingly, in my experience, at that stage, if you tender that claim to the insurance carrier is going to deny coverage because the claim is premature, that you haven't received a demand letter, you have not received a lawsuit, and so they will deny the claim as being premature. It seems like a catch-22, and it sort of is a catch-22. On the one hand, your claim is going to get denied because it's premature. You thought it was premature, and sure enough, the insurance carrier agrees with you. But if you don't, 9 months later, the insurance carrier says that they've been harmed by your failure to tender this in a timely fashion. So, what do? You play their game. You jump through their hoops. And maybe consult with someone at our office or attorney about the likelihood of this going to suit and the likelihood of or the advisability of tendering it. It's the game that they've set up, and there's not a lot you can do about it except act reasonably and fight back if you have to. The question is, should you always tender? So this is a tough question because it's not really a legal question. I get this question every now and then for small value claims. For anything significant, I would say you always tender. And the general default you will hear from, I think, attorneys is, yeah, you should tender. If you think it's a claim, you should tender. What about a small value claim, $2,000, $5,000, a nuisance value claim? No attorney on the other side. Should we tender those claims, or should we just try to work it out? Well, if you know from my previous hypothetical, that was a nuisance value claim. They worked it out, and then it starts to 9 months later, it comes back to haunt them. So to a certain extent, it becomes a business decision, because people also ask me about something like loss runs. Loss runs are the internal metric that insurance carriers have to measure how much you're costing the insurance carrier in terms of actual payout on claims and payout on attorney's fees. What's the total value of the claim? That if you have multiple losses during your time with the insurance carrier, you're going to have a significant loss run, and that dictates how much your future premiums are going to be and whether they're going to drop you entirely. That I've never worked for an insurance carrier. I've never worked inside of an insurance carrier and seen how they make those determinations. I can't advise on that. I'm not sure unless someone has actually worked in there. They could advise on that, and no adjuster is ever going to give you that information in terms of what impact this is going to have on my future premiums. So it's sort of a guessing game. It really becomes a business decision, I think, when it comes to tendering small value, nuisance value claims, it really becomes a business decision of whether you can quickly resolve this claim or whether you should tender it, have the insurance carrier possibly pick it up. They may pay for it, they pay for, the fees, but then you've got this loss run that's going to affect you in the future. Nuisance value claims is a tough one, and I know that, our general feeling is you tender it, but it's hard to predict what the tendering small nuisance value claims has on the future of the premiums of the policy. So who does the association tender to? Well, we kind of answered this question. There's the master policy, there's the D&O policy, and who else? Is there are there any other policies out there that the that the association has? It's usually not. That's it. If you're going to be a defendant, if you're the target from a claimant, from a unit owner or an outside party for a lawsuit, those are the people those are the two insurance policies that you're going to tender to. But now I'm going to shift a little bit, and I'm going to give a hypothetical where, sorry, I have this cough. So we've got another question. Does tendering in this context refer to any damage claim made to the insured or only to legal actions brought by unit owners against the association? I'd say it's so the question is, are we just worried about legal actions, or are we worried about claims for damages against the association? And I would say that we're talking about both things, because a claim for damages today could be a legal action tomorrow. A water intrusion today could be, especially by a litigious unit owner, could be a litigation tomorrow. That's why I say if it seems like there's going to be an issue coming down the road, you want to tender that off to the insurance carrier. And a lot of, insurance, if you've got water damage in the unit, there is a process, and I didn't get sort of into the process here, where hopefully the unit owner has an HO6 policy, they tender to their HO6, they're going to pay the deductible for, if the damage to the unit is above the deductible for the insurance policy, that's when their HO6 is going to kick in, and everything above that is going to be kicked in by the master policy if that water intrusion originates from somewhere from a common area. So that is that's sort of the standard practice. And in that case, you already heard like the magic words. There's water intrusion in the unit. It's $60,000 worth of damage. There's a $25,000 deductible. So you're going to be tendering to the master policy, I would imagine. And hopefully there's an HO6 policy in place, and the unit owner's got that covered through they have the $25,000 deductible covered under under their HO6 policy. So in that case, we don't have a lawsuit. We've got damage alleged. we've got the tender. These things happen and I know everyone probably has got a lot of experience with those. Hopefully it doesn't get to the point where there's an actual lawsuit claim, but sometimes that's just what happens, and that's when you call up our side of the firm as opposed to everybody else who helps out with all the other myriad issues that I know MEEB helps out with. So let me take a look at this. This is another situation. This is a complete reversal of where you, the association, is the target. This is where the association now has been injured and wants to go after, say, a roofing contractor who, during the course of their business, has damaged the roof, or they've caused damage to the common areas or to the units during the provision of their services. During the roofing contract, they've, I've had one instance where a tarp was left unattended in a storm and rainwater came in and damaged common areas and the units. Do you tender into that situation to the contractor's insurance carrier? And you see from claimants a lot of times they do tender to insurance carriers for the defendants. So in this case, a unit owner tendering insurance to the insurance of the association, or someone who slips and falls on the property wants to tender to the insurance of the association. Here, where the association wants to tender to the roofing contractor, in my experience, not a lot comes of this. The roofing contractor's insurance carrier has a contract with the roofing contractor. Unless the association was named as what's called an additional insured under the policy, or that additional insured is an AI, it's called AI, it has AI coverage. The insurance for the roofing contractor doesn't have any real obligations at this stage to the association to cover damage for the roofing contractor. What you really should do is set a demand letter to the roofing contractor and have the roofing contractor tender to its insurance carrier. And that's how you get the insurance carrier on board. Does it hurt to tender to the insurance carrier for the roofing contractor? No. Does it put them on notice, and may there be some benefit? Possibly. I think I just try to be realistic with folks and say, probably not that anything is going to come of this. You're probably not even going to get a response from the insurance carrier for the roofing contractor because you're not the insured for the roofing contractor's insurer. It's the roofing contractor. But you never know. So it is in every instance is a little different, and you should talk about if that's a sort of an aggressive tact you want to take. You should talk about it with your attorney, but at the very least, you should definitely get a demand letter out to the roofing contractor, demanding that they put their insurance carrier on notice. So we are right now we are at a point where you've sent out the tender, but you don't have a coverage determination yet. Before I stop that, we got a question. What happens when the master policy requires a hold harmless and that didn't happen? Can they deny coverage? I'm going to ask the person who sent the question, maybe give me a little more detail on what you mean by that, or send me, my email is in the beginning, and you can email me or give me a call about that's. Factually, I'm trying to work through what that's going to look like. I don't want to get too derailed, so I want to answer everybody's question. So feel free to email me or give me a little bit more information here, and I'll try to answer it. So this is pre-coverage determination communications with the carrier. Here's the thing: the insurance carrier is going to ask for more information. They love to do that. There's something called the 8 corners rule, which is that there's a piece of paper that is the insurance policy. That insurance policy has got 4 corners. There's another piece of paper that is the demand letter or the lawsuit. That piece of paper has got 4 corners. Together, those 2 documents have 8 corners, and the insurance carrier should be looking at those 2 documents, the 8 corners of those documents, to determine whether there is coverage. Now, the first thing insurance carriers, the adjuster, is going to do is they're going to reach out to the property manager or the association and ask for more documentation to help them determine whether there is coverage present. In those cases, we are always try to be very cautious in terms of our communications with the insurance adjusters and cautious in what kind of information they're providing. Insurance carriers in Massachusetts are entitled to what's known as undisputed extrinsic knowledge of facts. That is, facts that they could sort of, basic facts that may not be within the 8 corners of those 2 documents that they could discern for themselves, but they're always going to ask for more. And you have to be careful, because one of the things they're going to ask for is, hey, when did you first receive notice of this? Did you get it in the emails? Was there some message in the portal? And that's where one of the things they're looking for there is to say, oh, well, did you, how far back did those notices go? Because they're looking for ways to say, oh, you knew about this 9-12 months ago, didn't you? And you didn't provide us with notice, so your communication or your tender is late. So you want to be wary of that. To determine whether there's defense of this claim, it's really the 8 corners. They have to look at the 8 corners of these 2 documents. They're allowed to look at outside information, but you want to be wary about what information they're looking for. So I would usually say in those instances, consult with an attorney. You do want to be cooperative with everybody, because this is, it's a business relationship, and you certainly don't want to mislead or misguide and never, ever commit any kind of fraud with the insurance carrier. Absolutely not. So you do want to be forthcoming with information, but you do have to be careful. And it's really, there's no bright line rules here. It's really a sort of a kind of a case-by-case determination. The good news is, in most cases, the information you provide, 100% of it usually is helpful, and it will help establish that they do in fact have coverage. There's 3 basic determinations that the insurance carrier can make. They can either accept the coverage, they can accept it subject to a reservation of rights, or they can deny coverage. So we can go through what each of those mean and how we can kind of fight back on the bad one, which is denial of coverage. If your tender gets accepted, that's great. That's great news. But you have to make sure that, you have to know what that means and what that is going to look like. So you're going to get a letter, and that's going to be denied. That's going to be accepting the coverage. Watch for pre-coverage determination letters. This isn't an actual coverage determination letter when they use the word pre-coverage. So they're still looking for more information. That's probably what that's about. They're leaning down this path, but they need some more information just to finalize that coverage determination. What you want is the carrier is accepting all defense and indemnity obligation, all of its defense and indemnity obligations under the policy. Period, full stop. That's what you want. These letters should generally be short. The carrier's got no benefit to making these long, drawn-out letters. And your adjuster, who's overworked and probably underpaid, is writing these, so they don't have any desire to make these longer. If there's more verbiage, if it goes on to 2 pages, if it goes on to 6, be careful, because you're probably not getting a coverage. You're not getting an acceptance of coverage in that case. You want to look for red flags like the word reserves or the word reservation. If you see either of those words, you should be wary. And in all cases, I would say, if you're working with someone from our office or you're working with an attorney, send it to them and say, hey, they're accepting coverage, right? I just want to make sure. If they are, great. What that means is, if they've fully accepted coverage, what that means is they're probably going to go out and assign panel counsel. And panel counsel is someone off of their list that will then defend the claim for and get paid by the insurance carrier. That's fine. That's just the way it works. They have that right under Massachusetts law if they fully accept coverage to appoint panel counsel, and panel counsel will control litigation and will communicate with the insurance carrier about the sorry, we've got there's some questions coming. I'm gonna try to address them sort of at the end. But so I apologize if I see them, but I'll get to them. The panel counsel is going to be controlling litigation. So full disclosure, like working with panel counsel, for 20 years, I was panel counsel for a variety of insurance carriers, working with the Community Association Underwriters, panel counsel for them for a while, panel counsel for many other insurance carriers. They're fine attorneys. There's nothing like there's no issue with them. The most difficulty you probably have is they're overworked like everybody else, but they're just as dedicated to defending your claim, and so you should be aware of that. Probably the worst thing that's going to happen is if you got a question from the insurance, if the insurance carrier has a question and you have a question, insurance carrier probably is going to get their question answered first, but that's probably about the worst part of it. You should call them up, introduce yourself if they don't do it first, give them all the information they need, have open line of communication with them, because they're going to be defending you in this lawsuit. Be wary of admissions and disclosures you make. Remember, those are all public records. So if it can be, you want to be thinking about how this affects the whole association going forward. Panel counsel might have blinders on. They want to resolve this case, and they may not be thinking about the long-term impacts on the association. So just keep that in mind. It's not that they're going to undermine that, but you want to keep that in mind. And you also want to keep records of the litigation and the settlement. I'll just give one example, kind of an unusual example that happened recently, where there was panel counsel that was brought on way before I became involved. They resolved a slip and fall lawsuit in a common area. And basically the association got nothing. They had no information whatsoever from panel counsel except that an announcement that the case was resolved. They didn't even get a copy of the settlement agreement. It was a little unusual. It's definitely not best practice, and we've been working on getting all the documents that arose from that litigation. But it was a little strange. They were protected under the settlement agreement. The case was dismissed. They hadn't signed it, and they really hadn't gotten any notice except one day, a message saying, "Hey, your case was resolved. Congratulations." So it was a little strange, but we're working with the association and with panel counsel to make sure that they have all their correct information. If you get a reservation of rights letter or ROR, this is where they have accepted coverage subject to a reservation of rights. So what the insurance carrier is saying is, yes, we are defending. Yes, we are likely indemnifying any kind of claims against you, but we are doing it subject to reservation of rights that we may disclaim coverage or deny coverage at a later date. This is how most, especially property damage or construction-related issues, how most cases are handled under an ROR. And it's probably how, when I was panel counsel, I probably handled 90% of cases were subject to an ROR. Maybe that's an exaggeration, but a lot of them are. I can't think of a single time when an insurance carrier later disclaimed or denied coverage after accepting the tender subject to an ROR. They do it for reasons. And it's certainly if it comes out that there's some sort of fraud in providing or trying to obtain the coverage or something like that, you're going to get coverage denied at a later date. But 90% of the time, the insurance carrier, or I mean, more than 90% of the time, the insurance carrier just defends the claim, indemnifies at mediation or trial, and moves on. And it doesn't become an issue. But you're going to see it if you tender to insurance carrier, because this is how most of their, or this is how many of their claims are accepted, subject to an ROR. What does that mean? Well, the first thing it means is that under Massachusetts, you, the association, can choose your own attorney. So you've been working with us, you can keep us on and defend the case. The insurance carrier then pays our fees instead of you paying our fees. And we, the association in our office, would control the litigation in terms of, discovery, motions, mediation, and trial. Our office would be working with you to control the litigation. That's probably the biggest difference from an acceptance of tender where the insurance carrier, a full acceptance of a tender where the insurance carrier then retains the right to appoint panel counsel. So this is, and we do this all the time. I have plenty of cases where I represent the association in the defense of a claim subject to a reservation of rights. Carrier, we send the bills to the carrier, and the carrier is basically paying the fee. And then when we get to mediation, the carrier is putting up the money in order to resolve the claim. The insurance carrier uses some tactics. There's some kind of unfortunate tactics it uses at this stage when it is trying to decide between full acceptance of a tender and a tender subject to a reservation of rights. So one of the things it does is it cuts the association's lawyer. So let's say it's me. It cuts us out of the communication. It communicates directly with the association. There's nothing wrong with that, but it's when, I guess I should say there's nothing illegal about that, but when we're involved, you kind of expect to be involved in the communications, and you can see why we get cut out. It sends out letters with confusing language about coverage determinations. What it kind of does is it sets out that letter that says that, yes, it's accepted, its, and defense and indemnity obligations, but subject to, the long ellipsis, but subject to a reservation of rights. May not use the word reservation, may use other words that, euphemisms for that. And again, like I say, like if the letter goes on for 2 or more pages or it quotes policy language, you're not getting a full acceptance, you're getting an ROR, you're getting a reservation of rights, and you should know that. One thing they'll do is they'll hire panel counsel, they'll retain panel counsel to come on, and panel counsel will call you and say, hey, guess what? I'm your new lawyer. We're going to be filing a notice of appearance shortly. Hey, can you send me all the documents regarding this case? And we won't know. Maybe we will already put in a notice of appearance and you'll have 2 attorneys, and you won't have a full acceptance. You will have a reservation of rights. And what you want is you do want that full acceptance by the insurance carrier. Like I said, most times nothing bad happens, but they are reserving their right to deny your claim at a later date. And I guess I should say here, where that probably is most problematic is if it goes to trial, because they're going to be looking for, most cases settled mediation, but at trial, they may be looking for breakout of damages, and some damages the insurance carrier may say are covered by insurance, and some damages aren't covered by insurance. And so you want to be very wary of that, because that's where it can really come back to haunt the insurance. It can come back to haunt the association if they've been operating this whole time under a reservation of rights. So that is those are sort of common tactics. At this point, I would also just say, you may ask yourself, who's paying for all this? Is this something we can charge back to the unit? At this point, unfortunately, I would say you probably can't charge this back to the unit. At least these communications with the insurance carrier trying to obtain insurance. If the claim originates out of the unit, because there probably is active litigation going on, and it may be subject to the authority of the court to determine whether attorney's fees are warranted. If they do accept insurance, if they do accept coverage, one thing I advise clients is to take the fees and costs that have been incurred to date and send them off to your insurance carrier and say, hey, if it's subject to a reservation of rights, should you guys be covering this? Because you should have picked up, because you have you were going to be paying the fees going forward for the attorney. There's been some success with that. But it's sort of an individual issue that you have to kind of determine case by case. Really, that operative date is when you give notice to the insurance carrier, when you tender. That's when they should start paying for the attorney's fees, in my opinion. And so we've had some success, and you get some pushback as well. So we get to the denial. This is the third thing they can do. They can accept subject to a reservation of rights, or they can deny. So if it's a denial of coverage, this is, you'll know it because it'll say denial of coverage. And there's two big reasons why they deny it. Timeliness, which we've talked about several times, and I'm not going to kind of belabor it, and policy provisions. Timeliness is really a reasonableness argument, I feel, and in both of these instances, when you get a denial of tender, you want to talk to, I think, an attorney. I would recommend that. If you haven't been working with us before, that this is an instance, or if you haven't been working with whoever your normal attorney is, you want to talk to them about this denial and trying to push back, see what their reasons are, because timeliness is really a reasonableness issue, and you have to look at the length of time that has passed and whether they've actually been prejudiced, because they're always going to claim prejudice when there's been a delay in tendering to the claim. The other way is policy provisions. This is a lot of damage to that condo. Policy provisions that are typically excluded. Here's a list of them. I think a lot of people who deal with insurance know that these are ones that are going to get your coverage denied. The two big ones in my experience are come down towards the bottom. One is mold, and one is wear and tear. Mold is always going to be excluded. Hopefully, whatever claim is being pled is the practitioner on the other side knows enough to not just plead mold, because it's very rarely is it mold. It's water intrusion, it's damage to property, it's degradation of property, and resultant mold. If it's just a mold claim, you're gonna be in trouble. But because mold has been excluded now for years, for decades really, by insurance carriers, because it's so abused by plaintiffs' counsels in terms of claims, and it's so difficult, so easy to allege, and so difficult to get rid of. So that's one that's going to usually almost always be excluded. The other one is wear and tear. The insurance carrier isn't insuring your maintenance duties. So if, from their perspective is if there's a wear and tear issue, that's on you. That's on your maintenance practices, and it's not going to ensure that. But I had a recent case where we got that reversed, and I'll talk about that in a second. But that's for the master policy. For the D&O policy, it's intentional torts, intentional acts by the board members, and also acts outside the scope. In legalese, that's called a frolic. That's when you take the company truck and you go to a bar and you have too much to drink and you crash the company truck. That's, if there's something that sounds similar in a association context, that's not going to be covered because you weren't supposed to be using the company truck to go to a bar. So that's those are acts outside the scope of the trustee's duties. And you should just be aware that you're probably going to get excluded for that. One really frustrating one I see a lot is there's a water intrusion claim. They sue for negligence, and then they also sue for breach of fiduciary duty. And they say, as I said before, you should have you should have you should have seen this coming. You should have done something to prevent this water intrusion. And what insurance carriers a lot of times do for D&O coverage is say, hey, we exclude physical damage to property. We exclude water intrusion. So we're going to exclude this claim. And my perspective is, look, there's one half of this claim is actual water damage. The other half is the acts of the trustees themselves. There'll even be a breach of fiduciary duty claim asserted. And the insurance carrier is like, no, we have an exclusion for water damage, so we're not going to cover these other instances. It's very frustrating. And you maybe have some success getting that reversed, but a lot of D&O carriers look at that and they say, well, what they really are saying is, hey, there's probably a master policy out there that'll cover this, so go talk to them. They're not really saying that, but that's what they're thinking. And the master policy hopefully steps up and covers that. So you get the denial letter. What can you do? Well, you do have the right to challenge the coverage determination. You should be aware of that. So what we always say is go back, talk to your attorneys, and see what the denial letter is actually saying, and see how you can fight back against that denial. So you want to be aware of your rights, and you don't want to waive any of your rights in these situations. The first thing I recommend is you're going to respond with a demand letter demanding now that they accept defense and indemnity. That kind of lays it all out. And my preference is send out the demand letter, and hopefully we can make them change their mind. Step 2 is threatening a 93A or 176D claim. 176D is the Insurance Carrier Act, and 93A is the Consumer Protection Act. These work hand in hand in the insurance context. They provide a series of guidelines under Section 9 of 176D that the insurance carrier needs to follow, like a timely response to a request for tender and a reasonable basis for the denial of tender and stuff like that. We can take a look at that. We can take and see what they have said in their denial. And we can get a response out that alleges 93A 176D. You may not get a response to the demand letter in step 1, but you will get almost certainly a response to a 93A 176D letter, usually within 30 days. And it's usually going to be not from an adjuster, but now from a coverage counsel, a coverage attorney who's getting paid by the insurance carrier to defend them. In my experience, if you get a response from an attorney, they're probably saying no. If you do get a response from an adjuster, it's usually they've thought better of it and they've reversed course. These letters are factually intensive and require a lot of policy analysis. Your denial letter is probably going to be somewhere between 15 and 20 pages because it is citing all sorts of coverage issues. And it's citing policy language. The response letter is usually, it can be that bad. It can be that factually intensive in terms of citing policy and citing facts of the case and citing the law. Typically what we need right out of the get-go is the policy itself to look at it and we're going to have to, do some homework in terms of what happened, what was alleged, and why there should be coverage here. The fighting back against them, you will, two obvious things that they often do is they don't provide much in the way of documentation or supporting evidence for the assumptions that they make. So they will make assumptions that this is really about wear and tear, right? I mean, there was no break in the pipe. This was just a degradation of the pipe over time. And they'll make that assumption. And that won't be in the complaint, and that won't be in the demand letter, and that won't be obviously in the policy. So you can, that's sort of low-hanging fruit where you can fight back and say, look, you're just making these assumptions. Nowhere in the complaint is that. And by the way, we don't think that. If we can make that good faith argument, we can make that good faith argument, and we'll do it. So that's sort of low-hanging fruit. The tougher fight is to really get into the policy, look at those exclusions and look at exceptions to those exclusions, and try to find coverage that's in that policy. Recently, someone came to me, a property manager came to me with like what I just alluded to, a degradation of a pipe. The pipe degraded from the inside, released steam, but it's finally broke, released steam, and the steam went up the walls and damaged a unit for well over $100,000 in damages. When I first heard this, I said, well, the bad news is, it sounds like it's a wear and tear issue. And I want to be honest with you. I don't think, we're not going to get much, I don't think, but I'll take a look at it and I'll take a look at the policy. So factually, it wasn't very good. Getting into the policy, there was in fact a wear and tear exclusion in the policy. So we're dead in the water there. But there was also coverage for the release of water or damage caused by the release of water, which is exactly what steam is. And this was sort of a concurrent coverage under the policy. So I conceded that, sure, you got a wear and tear exclusion, but you've also providing coverage for water damage in this under this policy, and that is exactly what happened. The steam is water, and it went up and it damaged this unit. You should be covering this. It was a lot more complicated than that. There was a lot of pages. Because there were a lot of other arguments that were being made. But very pleasantly surprised when got notice like a month later after that letter went out, and the property manager had a check for almost $200,000 with the insurance carrier completely reversing themselves on their denial of coverage under the wear and tear because of that water damage that was covered. So it was a great result, and it was sort of you really have to kind of dig in. You got to look at the policy when you get one of these denials. And I really think it's worth it when there's a significant claim that you're looking at. In this case, it was well over $150,000, and they covered a variety of, the insurance carrier covered a variety of things for that. You're also, of course, stuck in this case with kind of who pays for all this. I mean, it's really, at this stage, it's still sort of an association. It's going to be picking up the ticket unless we get at a later date a judge saying, yes, this should all be paid for by the unit owner. But in the interim, if the insurance carrier does reverse, and there is active litigation, and they do reverse the denial, and they do decide to accept the tender, I would say take all these bills, send them to the insurance carrier to say, hey, you guys should pay for this, at least everything since the date of tender. You may also have a deductible, and if they don't want to pay just our bills, well, say, hey, then we deserve an offset on our deductible. I think that's eminently reasonable. Final thing is step 3 is initiating litigation. If everything else fails, do you want to initiate litigation? coverage litigation is very specialized. And I'm not going to give any kind of advice on this because it's really a case-by-case determination, but it is a very specialized area of law. If you're actually going to file suit, usually in federal court, and the claim needs to be significant. We do a lot of fighting and a lot of pushback on coverage denial letters. But coverage actual litigation, that's sort of the third step, and that's something, if all else fails, you should talk about with your attorney. So I've gone long here, and I apologize. But I know we have some questions, and I'll just look at them very quickly now. If you're still on, if you're dropping off, I appreciate the time. And let me know if you have any questions via email or give me a call, because I can always try to answer them. So we have a question: if you sign off on a check from an association, can you go back and obtain more money? Usually, so that would be a check from the insurance carrier. Usually they're going to want a release. They're going to want a release of that claim. So you're not going to be able to go back and obtain more money. But I would, of course, always recommend that you read whatever they sent you, and handle it and make the determination then. There's probably some some verbiage in the letter they sent in closing the check, or an actual release agreement that's going to say, hey, this is it, we're done. Especially if they are reversing course on a denial and reluctantly accepting tender. So let's see here. What if so here's one. What if the association doesn't want to settle and feels the claim is frivolous? There's something called the hammer clause in most policies. You have to, and that hammer clause is how much control over the settlement the association has. So most insureds don't have a lot of control over whether the insurance carrier can settle a claim. The insurance carrier wants to settle a claim. Famously, doctors are usually the ones who don't have these hammer clauses. I think I've seen some policies where the association doesn't have the hammer clause, and I've dealt with that. So the insurance carrier can't force you to settle, but you want to be careful with that, because the more the insurance carrier doesn't, if it's under a reservation of rights, the insurance carrier doesn't want to pay us. So it's going to be looking to settle. And if you don't want to settle, if you want to go to trial, the insurance carrier is going to be very, 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 very upset about going to trial, paying for a trial, and possibly losing and having to pay more than it could just settle for right now under what it considers to be, under what you consider to be a frivolous claim. So look for the hammer clause, and then tread lightly. And keep in mind, settling claims, if you consider it to be frivolous, and so many of them are, we can work out arrangements where there's confidentiality agreements. The other side isn't going to talk about it, and try to cover yourself that way. I get nobody wants to settle a frivolous claim, but there's usually a lot of benefits to certainty, and ending litigation provides certainty. What is the reasonable time for an insurance carrier to reply to a tendered claim? Usually 30 days. You're always going to get, they're going to start communication and say, hey, that's why you sometimes get free coverage determination letters, and saying like, we're going to need a little more time on this. So that's a reasonable time. Their reasonableness in terms of responding is really dependent on, if there's coverage litigation somewhere down the future, that reasonableness comes in. But outside of that, the question is, are you being harmed? Is the association being harmed, and in a significant, substantial way? That's it. It's, they're aware of it, and they'll start sending up pre-coverage letters and getting you to. So someone asked, isn't mold a $10,000 cap? I think every policy is different. So look at your policy in terms of what's capped. There may be You may have monetary caps. The problem with a presentation like this is every policy is different. Even that water intrusion policy, water intrusion coverage that I mentioned, it's that verbiage in the policy. It was for that policy. Also, if you do file a claim, are you flagged for years? Are you flagged for years if you file a claim? Okay, that's sort of the inside baseball for insurance carriers. That's where I've never worked for an insurance carrier. I don't know that question. I would ask for a broker, your insurance broker, about that. That's where it comes in with a business decision. You may be, so they may be watching you, and that may be an issue. And that may be a reason why you want to try to settle a smaller claim. Again, that's sort of a business decision. Hard for me to say. You're not going to get an insurance adjuster to tell you one way or the other, I don't think. If you were affected by a common area pipe, do you sue the master insurance or the association? Well, if it's a common area pipe, you are going to want to, so someone's asking if they're affected by a common area pipe, do you sue the master insurance or association? That sounds like if they're affected, I would read that to be if their unit owner is affected, which I'm not, this advice is more geared towards association, because we don't represent unit owners. So I would say that you're probably, if it's a common area pipe, you're going to be tendering to the master association. You're probably not going to be tendering to a D&O carrier. So that's where you're going to want to tender. There is one question here. It looks like it's from sort of the perspective of the unit owner. And so I just say if there's, we don't represent unit owners. If you have general questions, you want to email me or give me a call, feel free to do so. I don't want to, my expertise, I don't represent unit owners, as I said, so I'm going to kind of refrain from that, because I know most everyone, every trustee is usually a unit owner as well, and has to put on the trustee hat and keep that hat on for these kind of issues. But if you have questions, feel free, give me a call, send me an email, I'm around. I don't see any other questions right now, so I'm going to sign off, but I want to appreciate everyone's time. Thank you very much. And like I said, any questions, any comments, feel free to let me know. Thank you very much. Have a good day.